As Deputy Attorney General Todd Blanche recently stated, the investigation of Mr. Homan was subjected to a full review by the FBI, agents, and DOJ prosecutors.
There is a question that has a one-word answer. In September 2024, undercover FBI agents delivered $50,000 in cash in a paper bag to Tom Homan, the man who would become the Trump administration's border czar. Homan was recorded suggesting he could help secure government contracts in exchange for that money once the administration took office. The exchange was captured on video and audio. Senator Sheldon Whitehouse asked Pam Bondi one question about it. Did Homan keep the $50,000? The question has a yes or no answer. Bondi has the answer. She runs the department that conducted the review, and she refused to say it 3 times. In a Senate Judiciary Committee hearing, under oath. That refusal is the opening of a story that runs much deeper than one bribery investigation. Whitehouse is not a politician who stumbles into hearings unprepared. He spent years as Rhode Island's Attorney General before entering the Senate. He understands exactly how the Department of Justice is supposed to work, exactly what testimony under oath requires, and exactly what it means when the head of that department refuses to answer a factual question about whether a current administration official kept $50,000 in cash that was delivered to him as part of a federal bribery investigation. He asked the question once. He asked it again. He asked whether Homan had declared the cash on his tax returns. Each time, Bondi redirected to Todd Blanche's public statement that the investigation found no wrongdoing. Whitehouse noted each time that finding no wrongdoing is a different question from what happened to the money. The $50,000 either went back to the FBI or it stayed with Homan. Those are the only 2 options. Bondi would not say which one. The Epstein client list is the second lie in the sequence, and it is the one that Bondi cannot explain away with privilege claims or personnel policy. In February, before the Senate, she told the American people that the Epstein client list was sitting on her desk. Those were her words. She had it. She was reviewing it. The Trump administration was going to end the cover-up. On July 7, 2025, the Department of Justice and the FBI released a report concluding that there is no Epstein client list and that Epstein ran no blackmail operation. The White House's explanation for the discrepancy is that when Bondi said the list was on her desk, she meant the totality of the paperwork. That is not what she said. She said the list. It was a specific promise made on camera by the highest law enforcement officer in the country. The July report directly contradicts it. One of those things is true. They cannot both be. Now stay with me, because the 50 pages are the most specific and most damning piece of evidence Whitehouse put into the Senate record. Ranking member. Robert Garcia of the House Oversight Committee reviewed unredacted files at the Department of Justice and found that more than 50 pages of FBI interviews and notes are being withheld from the public database. These interviews are with a woman who accused Donald Trump of sexually assaulting her when she was a minor. The FBI took the allegations seriously enough to interview her 4 times and forward the case to FBI headquarters in Washington. The department has placed only the first interview in the public database. The first interview does not contain the details of the allegations against Trump. The subsequent 3 interviews, which Garcia reviewed and which reportedly contain the specific allegations, are not in the database. They exist. Garcia has confirmed they exist. They are being withheld. When Whitehouse asked Bondi about this directly, she did not deny the withholding. She redirected to Director Patel. The Epstein Files Transparency Act, passed with a veto-proof majority signed by Trump himself, specifically prohibits withholding documents on the basis of political sensitivity or reputational harm to any government official. There is no exception in the statute for ongoing investigations when it comes to production to the committee. The 50 pages are not classified. They are not duplicates. They are the 3 FBI interviews that contain specific allegations against the president. Withholding them is not a judgment call. It is a violation of a federal law that the president signed. The suspicious activity reports are the thread that nobody has fully pulled yet. the Treasury Department automatically routes suspicious activity reports, SRs, to the Department of Justice. There were hundreds of SRs related to Jeffrey Epstein's accounts. Whitehouse asked Bondi how many of those reports she or Director Patel had investigated. Her response was to note that Whitehouse had received money from Reid Hoffman, whom she described as one of Epstein's closest confidants. That is not an answer to the question about SRs. The question has a number for an answer. Hundreds of suspicious activity reports about the finances of a convicted sex trafficker were routed to the Department of Justice. The Attorney General would not say how many had been reviewed. Bondi also refused to answer whether the FBI found photographs of the president with what a witness had publicly described as half-naked young women, photographs the witness claimed Epstein showed to people and used as leverage. The witness account is public. The question of whether the FBI found such photographs during the search of Epstein's safe or premises is a factual question with a yes or no answer. Bondi said she didn't know anything about that. According to unverified accounts from sources familiar with internal DOJ deliberations, the decision to withhold the 3 additional FBI interview summaries was reviewed at a level above the career attorney who handled the document production and was specifically flagged as requiring AG-level authorization before the public release was finalized. These accounts have not been confirmed. What is confirmed is that the first interview was released and the subsequent 3 were not, that Garcia has reviewed all 4, and that the content difference between the first and the subsequent 3 is the specific factual detail of the allegations against the president. The Qatar jet sits at the intersection of everything else. Bondi's office provided legal guidance that the president could accept a $400 million luxury aircraft from the royal family of Qatar without congressional approval under the Emoluments Clause. Qatar was, until recently, a client of Bondi's personally, paying her $115,000 a month as a registered foreign lobbyist. When Whitehouse asked whether she consulted with the DOJ Ethics Office before issuing that guidance, she refused to answer. When he asked whether she had recused herself from the review given her prior financial relationship with the gifting government, she refused to answer. The standard ethical requirement for any attorney with a prior financial relationship to a party is recusal. The Attorney General of the United States will not confirm on the record that she met that standard. The impeachment resolution is real and its articles are specific. House Resolution 119, submitted on March 17, 2026, contains 5 articles: obstruction of Congress through defiance of the Epstein file subpoena, defiance of the Epstein Files Transparency Act, abuse of investigatory and prosecutorial powers to protect Trump and target opponents, defiance of court orders, perjury in congressional testimony. The resolution is in the Committee on the Judiciary. Its path forward depends on whether members of the majority are willing to move it. That is a political question. The evidentiary foundation for it is not political. It is documented in the congressional record of multiple hearings across multiple committees. 282 former DOJ career employees have signed a public letter about the degradation of the department's institutional integrity. Over 1,000 former federal prosecutors have formally warned that the prosecution of the president's political opponents constitutes a democracy-threatening abuse of power. These are not partisan voices. They are people who served under Republican and Democratic administrations. They include national security prosecutors and career officials with decades of combined experience. Their consensus is documented. The current leadership of the Department of Justice is undermining the reliability of the American legal system. That assessment is on the record. Here is what the $50,000 question actually represents. It is not about one bribery investigation. It is about whether the Attorney General of the United States will answer a factual question about whether a current administration official kept government money that was delivered to him as part of a federal sting. The question has a yes or no answer. The Attorney General has the answer. She would not say it. If she would not say that, she will not say where the 50 pages went. She will not say whether the SARs were reviewed. She will not say whether the photographs exist. She will not say whether she recused herself from the Qatar review. A yes or no answer about $50,000 in a paper bag is the floor of accountability. We are currently below the floor. Stay with us as the impeachment resolution moves through the judiciary.